In 2016, I published a law review article where I was raising concern about the government's ability to collect a massive amount of data without a warrant. I warned that the Patriot Act, passed in just 6 weeks after 9/11 without real debate, created a back door for massive surveillance. I warned about government collecting, in that instance, cell phone location data without warrants, basically tracking your phones. And I wrote that the government essentially enabled itself to collect personal information indirectly, likely running afoul of the Constitution. That was in 2016, 2 years before the Supreme Court decided that law enforcement agencies needed a warrant to get cell phone location information. Today, we're watching the exact same pattern play out, but with flock license plate cameras.
Just take it down right here.
Hands out the window, everybody! Who is in the back seat? Nobody. Nobody? All right, take the keys out. On the ground. I promise I'll explain everything in a second. Okay? They come off as easy as they go on.
You're showing North Carolina.
It's a South Carolina plate that is actually 71.
This isn't it, but... So if this isn't it, why shouldn't it?
We stopped it.
Hey, if that's not the tag, why are we?
That's the tag that hit.
Trying to make sure it's South Carolina. This has been hitting all week. It keeps on hitting as a South Carolina tag. So if we need to verify the stuff is from before we start making this other stuff.
I apologize for it, but
okay, it's not okay.
And here's the part that should terrify you. Even when the courts eventually say that these cameras violate your rights, the victims still can't get justice. Why? Well, 2 words: qualified immunity. I'm Brandon Grable. I'm a civil rights attorney here in Texas. Today, I'm going to show you exactly how surveillance industrial complex exploits a legal loophole to avoid accountability. But more importantly, I'm going to show you what you can do about it, because unlike 2016, we don't have to wait for the Supreme Court this time. So let me take you back to September 11, 2001. The country is in shock. We're scared, we're angry, and within 6 weeks, Congress passes the Patriot Act. 342 pages, no real debate, no committee hearings, no time for anyone to actually read what they're voting on. Just fear and a rubber stamp. Now, buried in that bill was an amendment to something called the Stored Communications Act. That amendment added language about collecting connection records. But here's the problem. Nobody defined connection records. Not in the text, not in the legislative history, nowhere. This wasn't by accident. It was a feature, because this ambiguity gave law enforcement a new tool they could use without a warrant. Law enforcement started collecting cell site location information, or CSLI for short, without warrants, tracking where your cell phone goes, which means they were tracking where you went.
Police departments around the country are tracking more and more people using their cell phones. Once reserved mostly for federal investigations, cell phone tracking is now being used by agencies around the country. Maybe you think it's no issue, but according to the New York Times, documents from the ACLU show the practice is lightly regulated and varies from place to place. Some cell phone companies even reportedly have a list of surveillance fees ready for police agencies to browse and choose from. So, does this practice concern you in any way? What do you think?
And today's guest is Gail Bass from Right This Minute and KTAR. What are your thoughts on
yeah,
this?
It concerns me. And people say, what do you have to hide? I don't have anything to hide, but the police don't need to follow me if they have no reason
reason to think that I'm in Al-Qaeda. And by the way, I'm not in Al-Qaeda.
Yeah.
So I don't understand why they feel like they need this. And unless they suspect me of a crime, the police do not need to follow me. That's why they need probable cause in other situations. What probable cause do they need to track where I am if I forgot to pick up my kids from daycare? To me, it's an overreach.
And we said before that the rules and the process varies from state to state. Not everyone requires a warrant, a search warrant. Or a warrant of any kind.
Right,
I think that, if they have a warrant and there is, reasonable cause.
Absolutely. The idea that they would just arbitrarily start tracking people because they're suspicious of them doing something, it should be hard to get a conviction for somebody, because if you're sending them to jail for life or whatever it is you're looking for, I want you to have the best evidence necessary. And the best evidence necessary is not whether or not they went in the middle of the night to visit their girlfriend. I mean, come on. I mean, I think it's an invasion of privacy. I really do.
I just really think they need to have a warrant before they do this.
I mean,
bottom line.
If you have a warrant, then there's a probable cause that I'm up to no good. If they all of a sudden start tracking me, what for?
So what happened? Well, as the cases popped up around the country, there were various splits that formed, but largely most courts said it wasn't a search. They basically said you didn't have a reasonable expectation of privacy. Why? Well, you were sharing your data with the phone company, and it wasn't your information. It was the phone company's information. So they used a little-known rule called the third-party doctrine, and they said it applied, so no warrant needed. And that's what I wrote my article about in 2016, the issues across the country about whether law enforcement was violating the Fourth Amendment by collecting massive amounts of location data. If you're curious to read that article, I'll go ahead and link it in the description. But I concluded that at some point the Supreme Court was going to have to step in and resolve the debate. Because when courts can't agree on what the Constitution means, nobody knows what the law is. And when nobody knows what the law is, then qualified immunity becomes a get-out-of-jail-free card. So in 2018, 2 years after my article, the Supreme Court releases its opinion in Carpenter v. United States. Timothy Carpenter was suspected of armed robberies. The FBI got his cell phone location data, 127 days worth, averaging 101 location points per day. The Supreme Court, in a 5-4 decision, said, it's a search under the Fourth Amendment. You need a warrant. Why? Well, Chief Justice Roberts wrote, a cell phone faithfully follows its owner beyond public thoroughfares and into private residences, doctors' offices, political headquarters, and other potentially revealing locales. The court said that this kind of comprehensive tracking gives government an intimate window into a person's life, revealing not only particular movements, but through them, familial, political, professional, religious, and sexual associations. This is called the mosaic theory. Credit to Professor Oren Kerr for developing this concept. The idea is that individual data points might seem innocuous, but when you aggregate them, they create a mosaic that reveals intimate details of someone's life. And the Supreme Court said, it's a search. I, along with other legal scholars, were correct in 2016. The Supreme Court caught up in 2018. So I thought, finally, we won. This is over. Except it wasn't over. Because here's what I didn't fully understand in 2016. Winning the constitutional question doesn't mean victims get justice. Carpenter applied to new cases going forward, and it was limited to cell site location information. It said, going forward, to collect this specific information, you need a warrant. But what about all the people who were tracked without a warrant before Carpenter? What about the people whose rights were violated in 2005, 2010, 2015? This is where qualified immunity comes in. Officers say, hey, when I collect this data without a warrant, the law isn't clearly established. Carpenter didn't exist yet. How am I supposed to know? And the courts say, yeah, fair enough, you're immune. Now watch what happens next. Watch how the government adapts. So I thought, finally, they get it. The Supreme Court says you need a warrant for comprehensive location tracking, except the government just found a different way to do the same thing. Enter geofencing warrants.
If you have a phone with Facebook, Snapchat, Twitter, or Google, your phone is constantly looking to save your location and share it with the company. A law enforcement agency may be interested in that data if they think it'll be helpful in solving a crime, so they can ask a judge to execute what's called a geofence warrant.
It's a search warrant, not for a particular person, but to a Google or an Apple, saying this is a geographic region, say a city block, and a date and time, and we would like to know if you have any users that were in that location on that date and time, and if so, provide their information.
Let's give a hypothetical situation, say a string of strong-armed robberies. Police know it's the same suspect and method, but they don't know who that person is.
You could do a geofence warrant to say, okay, if we know we had a robbery at this location on this date, and this location at this date, and this other location at this date, let's do a search warrant for those 3 locations at those 3 dates and times and see if there's any person that is in those 3 boxes on all 3 lists.
They're controversial because people's records can be accessed who had nothing to do with a crime, which is why Helmer says investigators should write the warrants as narrowly as possible and only use them when necessary. They would also need to be backed up by other evidence.
You can't have the biggest fishing net and say, I want the whole city of Grand Rapids for this week. Number 1, you're going to overwhelm your investigators. But number 2, those people have a reasonable expectation of privacy, and you have no reason to request that wide of a scope.
As technology progresses, the more law enforcement can know about you.
So instead of getting just one person's location data for 127 days, like in Carpenter, they're getting everyone's location data for a specific time and place. It's a dragnet. Cast the net, see who you catch, then figure out if any of them are suspects. And guess what happened? The courts split again. Some courts say this is an unconstitutional general warrant. Too broad. You're searching everyone's location data hoping to find a suspect. Other courts say this is fine. Google has the data anyway. Third-party doctrine. Remember, it's their property, their data, not yours. Plus, the warrant is only for a specific location and time anyway. No foul. So look what's happening. Courts are split again. So of course, it can't be clearly established. So you see the pattern. 2001 to 2018, it was cell site location surveillance. The courts were split for 17 years. Carpenter finally resolved it. 2019 to present, we're dealing with geofencing surveillance. Courts are splitting right now. There's no Supreme Court ruling on it yet. The government doesn't just stop when they lose one surveillance method. They adapt. They find new technology. They exploit it for years while courts debate whether it's constitutional. And by the time the Supreme Court finally says that's unconstitutional, thousands and possibly millions of people have already been surveilled. And qualified immunity means those victims get nothing. So this brings us to the next evolution: flock safety cameras.
Throughout the country, communities are installing automatic license plate reader cameras. They watch every vehicle that drives by and use AI to create a vehicle fingerprint. Police and other government officials can then use the database to track a vehicle without a warrant. These cameras have raised massive privacy concerns and sparked fierce debate. Recently, Denver City Council voted to reject a contract with the ALPR provider Flock Safety after residents spoke up.
Developing now, license plate reader cameras might be no longer in Denver after the City Council voted to not renew the contract with the tech surveillance company called Flock.
We recently cross-referenced an open source map of camera locations with Google Maps and found these cameras outside many places where people would want privacy. Locations included an abortion clinic, a church, an immigration attorney's office, a gun range, a teen halfway house, an STD testing clinic, and a mosque, among other locations. Concerns about how easily someone can access the information these cameras collect are not hypothetical. As these cameras pop up in more communities, the ability of police to conduct constant surveillance will only grow.
Artificial intelligence extracts the license plate number, make and model, color, bumper stickers, roof racks, any distinguishing features. And here's the key. It's shared across multiple cities and jurisdictions, potentially across the country. A cop in Virginia can search for your car and see when you drove through flock camera in North Carolina. No warrant, no probable cause, no judicial oversight. In Norfolk, Virginia, where the Institute for Justice is suing, there are 176 flock cameras throughout the city. The police chief literally testified it would be difficult to drive anywhere of any distance without running into a camera. Expert analysis shows that nearly 80% of all routes in Norfolk are captured by these cameras. Now here's where it gets crazy. Let me show you what's happening in Virginia, sometimes in the same courthouse with the same judge. Commonwealth v. Bell, Norfolk Circuit Court, May 2024. Judge LaCruz rules that the flock system constitutes a search within the meaning of the Fourth Amendment and requires a warrant. So the evidence in that criminal case was suppressed. The defendant wins. Commonwealth v. Church. Same judge, same court. Again, the judge says that the flock is a search, so a warrant is required. Evidence suppressed again, another win. However, the state wasn't going to sit by this time. They appealed that ruling. And just a couple of weeks ago, the Court of Appeals reversed. They said the flock system simply took photos of the license plate and Church's vehicle as he drove it down public thoroughfares. The circuit court erred in ruling that a search warrant was required, basically saying you don't have a reasonable expectation of privacy that your vehicle is going to be photographed as you drive down a public roadway. So the evidence was not suppressed. Virginia wins. Same city, same cameras, same data, opposite result.
But wait, there's more.
United States v. Martin, this time in federal court in Norfolk, October 2024. Judge Payne, the federal judge in the same city, says that the flock cameras are not a search because at issue were only 3 photos of a defendant's car in a 30-day period. You can't reconstruct whole of movements from just 3 photos, so the evidence was not suppressed. But in Smith v. City of Norfolk, federal court, the same Judge Payne, this time in a civil case, not a criminal suppression motion, denies the city's motion to dismiss. He says that the plaintiff's allegations that flock violates the Fourth Amendment are plausible. He writes that the complaint alleged facts notably similar to those in Carpenter that the Supreme Court found it clearly violates society's expectation of privacy. Law enforcement secretly monitoring and cataloging the whole of tens of thousands of individuals' movements over an extended period? Fourth Amendment violation. So the case gets to proceed to discovery. Let me say that again. Same city, same technology, same judge. In the criminal case, not a search. But in the civil case, maybe a search. Now here's why all this chaos matters for qualified immunity. Remember, to overcome qualified immunity, you have to show that the law is clearly established. That means every reasonable officer would understand that what he is doing is violating the Constitution. But if a Virginia state court says it's unconstitutional, the Virginia appellate court says it's not unconstitutional, the federal criminal court says it's not a search, but the federal civil court says, it might be a search, how can the law be clearly established? Well, it can't, which means officers get qualified immunity, which means victims get nothing. And it's the trap. The system requires clarity before victims can recover, but the system also ensures there won't be clarity until after thousands or millions of people have been surveilled. Let me show you exactly how this plays out in 2 real cases. Case 1, Robinson. She brought a lawsuit in Detroit, Michigan. In 2023, there was a drive-by shooting. Witnesses and surveillance identified the suspect in a white Dodge Charger with a missing left fog light, tinted windows, spoiler. No legible license plate on surveillance video. So the detectives ran to the flock system. They identified that the plaintiff's white Dodge Charger was photographed 15 minutes before the shooting about 2 miles away from the scene. Specifically, about half a mile from her home. So she was basically driving around her own neighborhood when the flock camera captured her vehicle. That's it. That's their evidence. Now here's what they didn't do. To check to see if her car had a missing fog light, it didn't. Both fog lights worked. Get a warrant. They admitted they had time, right? They didn't actually go to her house until the following day. And then also consider the fact that there were over 240 white Dodge Chargers registered in that area. They didn't check witness descriptions of occupants. They didn't account for gaps in the flock coverage. The system actually lost the suspect car after the shooting. Instead, they sent officers to her house. So while Robinson was in her garage with her child, officers pulled up, drew their guns, detained her child. They seized her car, impounded it, and then destroyed her belongings. Her car seat, employee ID, credit cards. When she gets her car back, she had to pay a couple $100 for the impound fee. So Robinson sues under the Civil Rights Act for Fourth Amendment violations. The result? Well, the case settled before the court could rule on qualified immunity, before the court could rule on whether flock cameras violated Fourth Amendment. No precedent, no clearly established law. The defendants likely paid a settlement to make it go away before the judge could rule whether their actions were unconstitutional. Now let me talk about case 2, a different result. In July 2023 in Columbia, South Carolina, the plaintiff and her passenger are leaving a neighborhood to go to a bingo event. The flock alerts officers by way of text message and notification on their computers that it just picked up the plaintiff's license plate and that it was a stolen vehicle. The photograph provided, allegedly because it wasn't preserved, was blurry, so officers could make out the letters and numbers, and they could see it was a white sedan, but that's it. The flock system also told them the direction of travel. So Deputy Zalewski spots the vehicle and calls for backup. Deputies Zalewski and Wolf conduct what they call a felony stop.
Intercept on Clemson. I'm approaching Clemson right now. I'm gonna light him up. Turn left into Clemson. Red light, I'm gonna light him up so he can be stuck.
Hey, just take it down right here. Hands! Hands out the window! Hands out the window, everybody! Who is in the back seat? Nobody. Nobody? All right, take the keys out. On the ground. Both hands out the window.
Get on the ground?
You're good.
Okay.
I asked for the keys on the ground.
Oh,
y'all
okay.
misunderstood. You're good.
Oh, okay.
You're gonna be detained, okay? I promise I'll explain everything in a second. Okay? They come off as easy as they go on. Don't mind my shakiness because I'm just driving pretty fast trying to catch up to y'all, okay? All right. You're not in trouble right now.
Okay.
But I am going to have you sit back here, okay?
All right.
I'll get the AC rolling because I know it's hot.
Okay. I've never been in handcuffs before.
Okay. So the tag on that car's come back stolen.
The tags?
The license plate? It's coming back stolen.
She just literally picked me up from my house. We going to a bingo event.
You stay down here?
I stay in Summit, yes sir.
Where you live?
I live in Legend Oaks.
Okay.
Okay. And she lives in Sumter.
Okay.
Okay.
Yeah, so that tag's coming back stolen. That's why we're coming out
okay.
like that,
right,
okay? Because
I'm
if
like,
the tag's stolen, there's a good
on?
chance that the vehicle's stolen.
Okay.
In our eyes. Okay?
Got you.
So, y'all comply? Cool, perfect.
Yeah,
I appreciate that.
Yeah.
Makes our job a whole lot easier.
Okay.
Okay? So, let us work through it, figure out what's going on.
Go ahead.
As a passenger, you'll probably be all right.
Okay.
All right?
Like, what is going on? Okay.
got your ID anywhere?
Is it in your
In the car?
What's your purse look like?
That's a 1040. We understand, Mike.
It's a green purse in the back.
It's in the back seat. Is it Chanel? Is it a little green with? Okay. It fell over, so I'm just putting the stuff back in there. Okay. Is your spouse in the military?
He just retired.
He just retired? Okay. Miss Ashman? Perfect. There you go, Bo. Did he kind of explain why we're here? Okay. Blackman, you got an open seat in your car? You got an open seat just so she can get out the heat? We're gonna walk over here and you're just gonna sit down in there, okay? Get you out of the heat, get you in some AC, okay?
She's good in your car?
Yeah, she's straight. She's
You
cool
want to pull
with
up a
it.
little bit?
Yeah, I'm about to move it.
It sure is, I think it's showing North Carolina.
It's a South Carolina plate that is actually 71.
This isn't it, so if this isn't it, why shouldn't I touch that?
He stopped her.
Hey, if that's not the tag, why are we?
That's the tag that hit.
Trying to make sure it's South Carolina. This one's been hitting all week. It keeps on hitting as a South Carolina tag. So if we need to verify this stuff before we start making this other stuff.
Yeah, she's the driver. Is your registration on the box?
No, it's not. It's in the back seat of that. It's in the back passenger seat.
You're good. Take
It's
a deep
behind
breath.
it.
It's in the back seat. Okay. Go ahead and step out, okay? That deputy's gonna get you out of handcuffs, okay? Hop on out for me. Alright, so the Alaska plate that is on it uses the same format South Carolina plates do. Okay, so 3 letters, 3 numbers. The South Carolina version of that Alaska plate is stolen.
Okay.
Not yours, okay?
Okay. Thank you.
So,
Miss Bailey.
yep, I apologize for it, but
Okay.
we apologize. Because I was the one that was talking to you. Do you have any questions for me?
The stolen plate was South Carolina. Alaska and South Carolina, like probably a number of other states, used the same letter number format. At least that was their excuse. But this plate literally says Alaska across the top. And veteran, the stolen South Carolina plate, completely different color scheme. And here's the testimony that should make your blood boil. Corporal Zalewski testified, a lot of times when the plates hit the flock, we might be right there and we don't even have time to do an investigation. And that's when we perform the felony traffic stop. Read that again. A lot of times we don't even have time to investigate. They're trained to go straight from flock alert to felony stop. Guns drawn, no investigation. When it comes to probable cause or totality of circumstances, Cops just rely on Flock. What is happening? So the result in this case, in August 2025, the federal court granted qualified immunity to the officers. The court noted that the record showed carelessness in misidentifying the plate or an error in judgment in initiating the stop prematurely, but the court reasoned it's these types of mistakes that qualified immunity was established to protect. Carelessness, error in judgment. They confused Alaska with South Carolina. They didn't even make out the correct type of vehicle. They didn't even run the plate when they got up on it to see who it was registered to, or if anything made sense. Two states that don't even border each other based on a blurry Flock photo without doing any investigation. And qualified immunity protects it. Case dismissed. The officers walk free. Plaintiffs get nothing. Now let me show you something that should make you even angrier. This is from a Flock Safety corporate deposition in the Norfolk case that the Institute of Justice is bringing. See all those black bars? That's information Flock doesn't want you to know. What's under those redactions? I don't know. Maybe the Institute of Justice knows, but the public certainly doesn't. Maybe it's how the AI actually works. What else can they track beyond license plates? Who else has access to the data? What are they doing with the data? Are there capabilities they haven't disclosed to the cities? So I decided to test something. If this is really just public data collected on public streets, and if there's really no reasonable expectation of privacy, as courts keep saying, then it should be available to everyone, right? Well, I emailed Flock Safety and I asked them. I let them know I was interested in subscribing to their service to view license plate data collected on public streets. Since the data is collected in public view, they should be able to provide that information on civilian subscription options. They did respond, but they said that the cameras belong to law enforcement. So what did I do? I responded back and said, I don't want the cameras. I want access to the data. Who owns the data? As of this recording, still no response. And here's what happened when I tried to call them.
Thank you for contacting Flock Safety, where our mission is to eliminate crime. If you are interested in purchasing Flock Safety products and services, please press 1 for our sales team. If you represent a neighborhood, HOA, community, builder, or improvement district, please press 1. For law enforcement and all other customer types, please press 2. If you represent a neighborhood,
answer.
Thank you for contacting the Flock Safety sales team. We're sorry we missed you, but if you leave a voicemail with your name, your organization, the best phone number to call back, and the city and state you're calling from, someone will return your call.
There you go. So let me ask Flock Safety directly, since I know someone from your company might be watching this. If the data is so innocuous, if it's just public information that anyone can see, why can't the public access it? Why only police departments get instant, unlimited, warrantless access? The answer is obvious. They know it's invasive. They know it reveals intimate information about people's lives. They just don't want you to know that. They want courts to think it's no big deal, just photos of cars on public streets. Nothing to see here. But if it's nothing, why the secrecy? Why the redactions? Why won't you let everyday people or civilians subscribe? Because it's not nothing, and they know it. So Flock won't tell us what they're hiding in those redacted depositions, but they're not the only ones keeping secrets. Let's show you what's happening 3,000 miles away in Oregon. In Eugene, Oregon, where there's a population of 175,000 people, the police department installed 57 Flock cameras throughout the city. Where are they? Nobody knows. The city is refusing to disclose the locations, claiming a security exemption under Oregon public records law. Seth May, a resident and member of a group called Eyes Off Eugene, filed a public records request. The city denied it. He appealed. They denied the appeal. So on October 20, 2025, the ACLU of Oregon sued the city of Eugene. Now, here's what makes this interesting. Eugene claims that disclosing the camera locations would undermine security. But Springfield, Oregon disclosed theirs, Medford disclosed theirs, and Woodburn disclosed theirs. So why is Eugene special? What are they hiding? So here's what's actually happening with Flock nationwide. And this is why cities don't want transparency. Exhibit A, Illinois.
Illinois Secretary of State Alexei Janulius has now ordered a suburban community to stop sharing data from license plate cameras with U.S. Customs and Border Protection. The Secretary's office discovering that the Forest Park Police Department gave CBP access to the data. Any data sharing capabilities have now been shut off. We have reached out to the Forest Park Police Department for comment, but have not heard back. Just last week, the Secretary of State's office learned that the company, Flock Safety, gave Border Patrol agents access to its license plate readers across the state. That has also been shut down.
Exhibit B, Texas.
Last week, we received disturbing news that police in Texas illegally access data from automatic license plate readers used throughout Illinois. They did so to track down a woman regarding an abortion care related matter.
Illinois leaders say a sheriff's office near Dallas tapped in to more than 83,000 license plate readers nationwide, looking for a woman they say had a self-administered abortion in Texas. The Johnson County Sheriff told an independent outlet that this was a safety issue and the woman was being searched for as a missing person, not as a suspect of a crime.
These are people that have committed what in some states is considered to be an immoral act, and in other states it is considered to be an illegal act.
The sheriff's office found her, but the woman was never charged. Criminologist Alex Del Carmen says this raises big questions about surveillance and politics.
The problem here is that if they went for an abortion-related case, they will go for absolutely anything. And that is what worries me, right? Which is, what is it going to be tomorrow?
Exhibit C, California.
The Attorney General of California visiting San Diego this morning to announce that he is suing the city of El Cajon. He says the lawsuit is a last resort, but that after months of conversations, the city of El Cajon still is not complying with state law.
State law SB 34 prohibits sharing license plate data with law enforcement agencies outside of California. The AG's office says the largest city in East County has continued to do just that, despite multiple warnings from the state's top cop. Per the lawsuit, El Cajon has shared data with agencies in more than 24 states.
We don't have specific knowledge that there was direct sharing with federal agencies or entities, but the whole point of the restrictions on sharing is that once it's shared with any entity out of the state of California, you lose control.
Bonta is worried about sensitive data regarding immigration status, reproductive health care, or gender-affirming care. Wells, who was taken aback by the lawsuit, says that's not what the 100 cameras in his city are for.
This system has saved multiple lives by us knowing what kind of people are in our city, what they've done, whether they're armed, whether they're dangerous.
The AG says the law is unambiguous, and El Cajon has been intransigent, unlike other cities, including San Diego, that changed their policies after the AG's office informed them they were violating state law.
Every other agency that we have reached out to when we had concerns managed to figure out a way to comply with it. Wasn't hard for them.
He hopes the suit will capture El Cajon's attention.
Exhibit D, Senator Ron Wyden investigation.
Senator Wyden not holding back on his criticism of the controversial license plate readers tonight. Wyden says flock cameras not only capture license plates, but can also detect make, model, and color of vehicles. Even bumper stickers have come under fire over privacy concerns and the potential that they can be used by federal agencies such as Homeland Security and ICE, as well as by law enforcement agencies from other states to track people or identify immigrants without legal status. In a letter to the CEO of Flock Group Incorporated, which owns and operates the cameras, the senator says, quote, abuse of Flock cameras is inevitable, and Flock has made it clear to take no responsibility to prevent or detect that. For that reason, I must now recommend that communities that have installed Flock cameras reevaluate that decision.
He goes on to say, quote, based on that research, it is my view that Flock has built a dangerous platform in which abuse of surveillance data is almost certain. In particular, the company has adopted a see no evil approach of not proactively auditing the searches done by its law enforcement customers because, as the company's chief communications officer told the press, it is not Flock's job to police the police.
Now, Flock Safety did respond to Senator Wyden, saying, quote, we already introduced a search filter protection for immigration and reproductive rights. Every sanctuary state and community can implement this protection so that searches related to these purposes will not include their cameras. Flock Safety also commented on Wyden's concerns about audits, emphasizing that they do not proactively or randomly conduct audits because Flock Safety is not an enforcement body, and the laws governing their customers, whether local, state, or federal, vary significantly. Meanwhile, tech company Amazon has announced a new deal with Flock to allow people who own Ring cameras to share their video with law enforcement agencies that use Flock software. That deal would allow law enforcement to request video evidence directly from Ring cameras, but it does give camera owners the final say on whether the video gets shared.
You see what's happening? This isn't just about whether Norfolk can track your car. It's about whether ICE uses Flock in sanctuary states, Texas uses Flock to track abortion seekers across state lines, agencies getting backdoor warrantless access, cities sharing data. In Eugene, for example, they're hiding their cameras because they know once the public finds out, they'll have to answer questions about who has access to the data. But I applaud the plaintiff in the Eugene case. Why? Well, they didn't wait for the perfect plaintiff. They didn't wait for someone's rights to be violated. They saw Flock coming and they said, not here, not without a fight. And that's what you can do. Here's what should terrify you most. Look at what courts keep saying in these cases. These are actual quotes. Kansas Federal Court 2024. This court must rule on the facts as they are and may not speculate about what the future may hold for Flock's capabilities. Virginia Appellate Court, last month. The 172 Flock cameras used in Norfolk are not as intrusive as cell towers and aerial surveillance equipment. Various courts in various cases. The future is uncertain. Perhaps as the technology evolves. Maybe when there are more cameras. At this time, the system is not comprehensive enough. Do you see what's happening? While courts are debating whether Flock is comprehensive enough to be a constitutional problem, Flock is adding cameras every single day. Tens of millions of vehicles tracked, hundreds of millions of data points collected, and growing. By the time the courts finally say, okay, now it's too much, we'll all be in the database for years. The normalization will be complete. In 2016, I documented how the Patriot Act created this exact problem. Congress passed it in weeks. September 11th happened, and by October 26th, it's law. 342 pages. No meaningful debate. Just fear and a rubber stamp. And then we spent 2 decades fighting in court about whether the surveillance it enabled is constitutional. And now we're doing it again with Flock. Except this time it's not even Congress. It's not even a law. It's police departments, city councils, private contracts with a private corporation, installing cameras on poles, collecting data on millions of people. No public debate. No vote by elected representatives. Just sign here, install there, and we'll let the courts figure it out later. What's happening with Flock? Well, in 2023, Flock explodes nationwide. Since then, courts are split everywhere. 2025, I'm telling you now it's unconstitutional. Whenever, Supreme Court will eventually rule. But the victims today, they will get nothing if we wait. And we don't have to. This time we could clearly establish the law now, before millions more people are surveilled, before Flock is in every city, before it's too late to stop. And that brings me to Norfolk, Virginia, because there is one case happening right now heading towards a ruling that could change everything.
Last year, we filed a federal lawsuit against the city of Norfolk, Virginia, over its use of flock cameras, arguing that constant surveillance without a warrant is unconstitutional.
The Institute for Justice representing this case says it's a big invasion of privacy.
In February of this year, a judge ruled our lawsuit could move forward, saying that a reasonable person could, quote, believe that society's expectations are being violated by the Norfolk flock system.
The Institute for Justice filed this case on behalf of Lee Smith and Crystal Arrington in October of 2024. Here's why this case is different from Robinson and Ashman. First, it's not a motion to suppress evidence in a criminal case. It's a facial challenge to the system itself. A declaratory judgment action seeking to have flock surveillance declared unconstitutional before more people's rights are violated. Second, the plaintiffs aren't suspected criminals with messy facts. They're ordinary citizens, a Navy veteran and his wife, who just don't want to be surveilled without a warrant. Third, if they win, it creates binding precedent in the Fourth Circuit that covers Virginia, Maryland, West Virginia, North Carolina, and South Carolina. That's huge. Fourth, and this is the critical part, if they win, then the law is clearly established for future cases. The qualified immunity trap closes. Of course, it would only be clearly established in that district and it will likely be appealed. However, it lays the foundation for other circuits and other districts and other states to follow. So here's the timeline. October 2024, the Institute for Justice files the case. In February 2025, they get their first major victory because the judge denies the city's attempt to have the case dismissed. The court tells them that they pled facts sufficiently to allege a violation of the Fourth Amendment. And the judge cites to Carpenter. He notes that flock creates surveillance of the whole of tens of thousands of individual movements. Translation, you might be right that this is unconstitutional, so I'm not going to dismiss this. Let's go to discovery and find out. So between March and September of 2025, discovery takes place.
As more information comes to light, it's clear just how pervasive this surveillance is. We recently learned the city of Norfolk collected 41 million records of vehicle movements in just 1 month, including nearly 300 records of one of our clients' movements. And it's not just Norfolk.
The Institute for Justice gets flock data on the plaintiffs, deposition testimony from Norfolk PD, deposition testimony from flock safety, heavily redacted of course, camera locations and coverage data, expert analysis showing nearly 80% of routes are captured, and the discovery revealed that officers can search without a warrant, probable cause, or reasonable suspicion. No supervisor approval required. Data shared across multiple jurisdictions. Just log in and take a look. And the chief admitted that it's difficult to drive anywhere without hitting a camera. So recently, both the city of Norfolk and the Institute for Justice filed for summary judgment. The Institute of Justice is asking the court to rule now that the warrantless flock surveillance violates the Fourth Amendment. So at this point, we're just waiting for the court to rule. That's it. That's the case. If the Institute for Justice wins, flock surveillance in Norfolk is unconstitutional. The law is clearly established, at least in that circuit, and future victims can cite to that case to overcome qualified immunity. And then other jurisdictions will have to confront the issue. But if the Institute for Justice loses, the qualified immunity trap continues. Flock expands unchecked, and we wait another several years for the Supreme Court. Norfolk is the battleground. So we've got Virginia courts splitting. We've got cities hiding camera locations. We have federal agencies backdooring the warrant requirements. We have state agencies backdooring the warrant requirements. We need a case that addresses all of this. And that case is Norfolk. All right, so by this point, you understand the pattern. You understand the trap. You understand why Norfolk matters. Now, here's what you can actually do about it. And I don't mean just share this video, though you should. I mean real action that changes outcomes in courtrooms and city councils. We need cases across the country in every circuit. We need a wave of litigation that forces the Supreme Court to take this issue. Here's how. Step 1, go to dflock.me. I'll put the link in the description and figure out if there are flock cameras in your city. Are they installed? Step 2, FOIA your police department. Request the flock contract, camera locations, search policies, training manuals, number of searches conducted.
A court ruling today raises new concerns about the cameras that dozens of Washington police departments use to catch criminals. Glad you're with us at 6:30. I'm Greg Copeland.
I'm Joyce Taylor. King 5 was the only TV news crew in the courtroom for today's hearing. As our investigator Chris Ingalls reports, the Skagit County case has implications statewide.
Here in Sedro-Woolley, where cowboys, loggers, and railroad barons built this historic town, new technology has been helping catch criminals. A half dozen or so Flock brand cameras are mounted along the busiest streets. These cameras can keep an eye out for stolen cars or vehicles that suspects use to commit their crimes. But earlier this year, Sedro-Woolley shut all its cameras down and asked a judge to settle a case involving a public records request.
You're a tattoo artist?
Yes.
Who files public records requests?
Yeah, on my free time, yeah.
Jose Rodriguez, who works in Walla Walla, is an ordinary citizen. He filed requests asking for images from flock cameras with dozens of police agencies. Many complied, and his records, some of which are shown here, reveal that flock cameras are shooting images all the time of passing cars and passengers.
You were worried about abuse of this system.
I felt like that's, I don't know, violating all of my privacy, everyone's privacy, regardless if you are obeying the law or not. It's not like a traffic light camera that takes pictures of only people that are breaking the law by speeding or whatever. It's taking pictures of every single vehicle that passes by.
He calls it surveillance by Big Brother. Sedro-Woolley denied his records request and
all rise, please.
Took Rodriguez to civil court.
This is a fairly specific issue regarding a very valuable and effective law enforcement tool.
Today, the attorney for Sedro-Woolley and Stanwood, which also denied the records request, said making flock images public would violate the privacy of individuals, and it would make them available to requesters with bad intent, like stalkers.
This is about ensuring that this technology is utilized in an appropriate manner.
This court case follows a University of Washington report last month that found federal agents accessed Washington flock cameras, possibly in violation of a state law prohibiting their use for immigration purposes.
I think a lot of cities are discovering right now that we don't know who all has access to this.
So we're here on the city's motion for summary judgment.
The judge ruled flock is so broad and indiscriminate, most of it not involving suspected criminals, that it must be released to requesters like Jose Rodriguez.
These images and data from the flock do qualify as public records subject to the Public Records Act.
After the judge's ruling here at the courthouse today, the attorney representing the cities said the judge's decision is under evaluation and it'll decide what steps to take next in this case. Meanwhile, the flock cameras in both Stanwood and Sedro-Woolley remain turned off. In Mount Vernon, Chris Ingalls, King 5 News.
Step 3, find civil rights attorneys. The Institute for Justice, ACLU for your state, local civil rights firms, law school civil rights clinics. Bring them this video. Bring them the Norfolk case documents. Bring them the documents you got from your record search. And ask them to file a facial challenge to your city's flock system. Maybe you don't want to sue. Maybe you want to just prevent flock from being installed in the first place. There are success stories, such as in New Orleans. City Council rejected flock in 2024. So what can you do? Well, attend your city council meetings. Public comment is powerful.
Residents, city council members, and some community organizations are firing back tonight at the mayor over flock cameras in the city.
Yeah, this after Mayor Johnston decided to extend the contract with the license plate reader company without city council approval. At a very fiery town hall tonight, many calling for his arrest. Fox 31's Talia Cunningham following the fallout here. New at 9. Talia.
Well, guys, it was fiery to say the least. Many claiming that Johnston made a quiet backdoor deal with Flock to extend the city's contract despite not having a city council vote or any public input. Tonight's meeting was very heated and came with what you would say a lot of passion. Listen.
We got the power. We got the power. What kind of power? People power.
You can see a lot of unity there. There was also some yelling at some points as community members slammed Johnston and his decision to extend the city's contract with Flock despite known concerns. An estimated 200 people showed up at tonight's town hall to make their voices heard. So many came out there was actually an overflow room.
A few moments later.
9 Denver City Council members are asking to stop a recently announced plan to keep Flock cameras in the city. Last week, Mayor Mike Johnston announced a deal with Flock to extend the contract 5 more months for no extra cost while putting restrictions on data sharing. Over the weekend, the majority of the council signed onto a letter asking the auditor not to sign the contract, saying in part there are still concerns over Flock's trustworthiness and the way that the deal was done behind the backs of city council members. The auditor co-signs all contracts, and he told the council that he would review the contract and make sure it meets city rules.
Organize with neighbors. Form an Eyes Off Your City group, like in Eugene, Oregon. Eyes Off Eugene forced transparency and litigation. Push for protective ordinances. Require warrants for ALPR searches. Ban data sharing. Require public disclosure of camera locations. Add sunset clauses like cameras must be reauthorized every 1 year or 2 years. Or better yet, run for city council yourself. More likely than not, city councils approve these contracts. If they don't approve the contracts, they can certainly enter an ordinance that bans these types of contracts without their approval. City council races are usually decided by hundreds of votes. Run on surveillance accountability. Win, vote no. You can also support existing fights. Norfolk, for example, with the Institute for Justice, this is the case that could break the qualified immunity trap. Donate, share their updates, attend oral arguments if you're local. Another one, the Eugene case, ACLU of Oregon. They're fighting for transparency. Support their public records fight. Look at your own state ACLU. Find your state chapter. Ask them if they're tracking the flock in your state. Offer to help organize. Spread this strategically. Don't just post this on social media and move on. Target it. Send it directly to criminal defense attorneys in your city. They need to file suppression motions, of course. City council members before they approve flock contracts. Local investigative journalists. This is a huge story. They should be looking into this if they aren't already. The pattern is predictable. The playbook never changes, and qualified immunity ensures the first victims get nothing. Unless we break the cycle. File cases now, pass ordinances now, clearly establish the law now. I was ahead of the Supreme Court in 2016. Let's all stay ahead of them this time. Norfolk is pending. Eugene is pending. Your city could be next. Don't just watch this happen. Be a part of it. This is clearly established. Thank you for watching.